Welcome to Law You Should Know. The law affects every aspect of our lives, our home, our jobs, and our recreational activities. Now you can learn about the law and how to protect yourself against the loss of your liberty or property. Learn how to stand up for your rights and seek compensation when you have been wronged. Your host for Law You Should Know is attorney Kenneth J. Landau with the Mineola law firm of Shane, Dox, Denisi, and Corker. He's a member of the Committee on Professional Ethics of the Bar Association of Nassau County and counsel to the Nassau Academy of Law. And now, here is your host for Law You Should Know, attorney Kenneth J. Landau.
Hi, this is Ken Landau, and welcome to Law You Should Know. Today we'll be learning about wage and hour litigation, and my guest is attorney Christopher Marlborough, and he specializes in this area of the law, and he has a law office in Melville, New York. Chris, welcome to Law You Should Know.
Thank you very much, Ken.
I know that you are involved in the specialized field of wage and hour litigation. That's part of the broader area of employment law. Tell us about wage and hour litigation. What does it involve?
Well, it involves largely wage and hour litigation involves the claims of the non-payment of overtime and minimum wage, where workers say they were cheated out of overtime, they were cheated out of minimum wage. There are some other claims, but it's mostly minimum wage and overtime.
And I know you like to describe it as theft, wage theft from these employees, sometimes low-level employees who are taken advantage of.
That is largely my experience, is that we're talking about a wage theft situation, that the employer knowingly cheats that worker out of minimum wage and overtime. Now, to be clear, there are some instances where there might be some misunderstanding, some borderline case where the person reasonably didn't know the rule, but many times I'll find that employers are engaging in tricks to circumvent the rules.
And part of the purpose of this show is to educate employees as well, so they know their legal record-keeping requirements. So how do these cases come about?
Well, these cases usually start with a plaintiff who knows that he's not being paid right, and he's tired of it.
And what are some of the shortcuts that employers might take in cheating the employee of wages?
Well, there are some areas where someone is not paid for any hours they work over 40 hours. So you work 50, but I'm going to put on your time slip that you worked only 40, and you're not going to get overtime. Or I'll make you work 50, I'll pay you for 50, and I'm only going to pay you straight time. I'm not going to pay you overtime. Or I'm going to pay you whatever I feel like. I'm going to pay you by the day instead of by the hour. And now I could make you work as many hours as I want.
So the minimum wage always comes into being, regardless of how many hours in a day you work. In other words,
you have to be paid a minimum wage, but set by in New York State, the New York State minimum wage is higher than the federal minimum wage, and you have to be paid that for every hour that you work, unless you're an exempt employee.
And what would an exempt employee mean? And what's the definition of that?
Well, there's quite a few different types of exempt employees, but those include executive employees like management, supervisors, things like that. Certain classes of professional employees unfortunately, you and I are professional employees. So we're exempt from being paid minimum wage. We could work less than minimum wage. And the
employer can't use that as a label to get around paying you the minimum wage and also overtime.
They oftentimes do. They will say, well, this dishwasher is an executive. But you have to satisfy several factors. You have to be paid a salary that is enough money to have that person be exempt, and you also have to pass the duties where you have the responsibility over other people, or the certain types of responsibilities that are necessary to satisfy that exemption.
And also sometimes employees mislabel an employee as an independent contractor so they don't have to withhold Social Security and provide other protections.
That's another very common scheme, is independent contractor misclassification. And I had a case. Literally, a dishwasher is an independent contractor. Why? Because you paid him on a 1099? What's independent about what he does? Is he allowed to exercise independent judgment in washing the dishes? The answer to that is no, he was not. In fact, we won summary judgment on that very issue. But unfortunately, many times employers will do that because it gives them an opportunity, A, to not pay the appropriate wages that they're required to pay the workers, B, to outcompete their competitors by cheating workers, paying less. Now, how's a legitimate businessman going to compete with that? And by not paying their proper amount of taxes, because they don't pay the payroll taxes, and they don't pay Social Security and workers' compensation and unemployment insurance. So there's a number of benefits that they get by misclassifying workers, and that's why that is rampant. And particularly in certain industries, misclassification is incredibly rampant all over the place.
And are there any industries where you typically, if you feel, give rise to an above-average number of claims?
Yes, certain low-wage areas of work have much more instances of wage theft. I've seen nail salons, restaurants, and a number of other. Construction is very common. Misclassification of construction workers is very common. I was just reading in the paper a couple days ago about $2.5 million that the New York State has gotten a judgment against workers, against construction companies for $2.5 million, which is just a small fraction of the $1 billion a year. Wage theft in New York State alone is a more than $1 billion a year industry, according to studies of the Department of Labor.
And so what type of a record is an employer supposed to keep to be in compliance with the law?
Well, that's a good question, and let me explain something to you about that question. It's important that in order to defend in a case, so if you get sued, the Department of Labor comes knocking on your door and you're an employer, if you don't have the records, there's a presumption that you don't have those records because you violated the law in the first place. And the value of the word of the worker gets much more weight than it would in a normal he said, she said situation. And the kind of records that you need to keep are working time records and pay records. And there are statutes that protect workers and provide monetary relief if an employer fails to provide appropriate pay records.
And does it help a worker to bolster their case and their credibility if they keep their own records, even if they're informal?
It is. It's often very difficult because when a worker's working there, they don't necessarily know that they're going to be bringing a wage theft case in the future. And in fact, many, many times, current employees are not the people who bring these litigations, or at least not the ones who start those cases, because they're afraid of losing their job. They're afraid of retaliation.
Even if you had an office job and you're not sure you're eligible for overtime, it's probably good to keep a record if you have to work any extra projects or work any evenings.
It is.
Just to keep open the possibility of a claim later in case you're not paid overtime or whatever.
Sure. In fact, the United States Department of Labor has an iPhone app that encourages workers who are contemplating bringing a claim to monitor the hours that they work, to document it. So that is something that does come into play from time to time.
And what about for prep time, for travel time, for scheduling time, or sometimes workers ripped off regarding those necessities prior to or during the workday?
Well, that's a good point. Each of those really has a different set of rules depending on what the situation is. There certainly commuting time, your time from work, from home to work, is not compensable. But if you get to work and then you have to go load up the truck with tools and something like that to get to your construction site, right? You're supposed to be getting paid from the time that you get to that office and start working at that office, rather than the time you get to the construction site and start doing the construction work. So all of this is time at the margins, and each of those there's a complicated set of case law that goes along with each of those.
Okay, so and sometimes these cases brought as a class action. So if you have some colleagues who are in the same boat or not being paid fairly, their cases can all be handled as one?
It is very rare instance where an employer is violating the wage theft laws with one employee and not all the other employees. So I personally practice a fair amount of class actions, and also what's called collective actions, which is under federal law. You don't have the same rights as under state law, and you can bring it with one person, and then the court could authorize a notice to go out to the other workers and say, if this situation is happening to you and you want to participate in this lawsuit, fill out this form and send it back in. And so that actually is much involves usually less people joining the case than in a class action, where you say, unless you want to get out of this case, don't do anything, and then you're automatically in the class action.
And is it true, let's say no amount is too small for you to, let's say, litigate over if there's a valid claim?
I would not say that's true. There's no amount that's too small, but if you are looking at a class action, that amount, that threshold, whatever that threshold amount, can be bet very quickly depending on the number of workers that you have. Right. So if you have 1,000 workers and you're ripping off workers by, say, a 15-minute break that they're not allowed to take, but you're deducting from their pay every week, well, you add up 1,000 workers, and that adds up pretty quick into a multi-million-dollar case.
And if they had to work at different locations, generally they would have to be paid for the travel time between locations?
Generally, yes. Under most circumstances, that's the case. If you're working so these are all relating to statute called the Portal to Portal Act, which is the commuting time, not compensable, but once you've arrived at work, largely that time in between is compensable because you are working. The boss says go to that job site, and you are going to that job site.
And do employees also literally have a clock, so there are issues about work they're required to do before they sign in or after they sign out? Like in, let's say, a department store, there was sometimes allegations they were required to do certain work before they clock in, right, and maybe certain work after they clock out.
Right. And that happens oftentimes. Workers are told to continue to do work after they clock out, which is, to me, a fingerprint sign that you're stealing from that worker, because you're trying to create a fake record. You're trying to create a lie, right? And that lie is that person stopped working at this time, and then you're making them do more work.
So if they're working, the bottom line is if they're working, they have to be paid for it.
Generally, that's the case, unless they're exempt, and then they can be paid a salary. Right.
Okay. We're going to take a short break, but when we return, we'll continue our discussion of wage and hour litigation, and we'll learn how cases are handled and some other examples of cases. Our guest is Christopher Marlborough. He's an attorney, and his office is in Melville, New York. And you're listening to Law You Should Know here on 90.3 WHPC, the voice of Nassau Community College, and also over the internet at ncc.edu/WHPC. We'll be back in a moment.
This portion of programming on WHPC is brought to you on behalf of the Nassau County Bar Association, who wants you to know about ADR, Alternate Dispute Resolution, which can help you avoid costly, lengthy, and uncertain litigation in court. By resolving disputes through mediation or arbitration, it gives you control over who decides your case. A mediator helps all parties to reach an agreement they can live with, or an arbitrator selected by the parties hears and decides the case. Your attorney can still represent you, but you control who decides your case. ADR is faster and less stressful than fighting in court, and it is a great way to resolve divorce, employment, or commercial disputes. ADR is now offered through the Nassau County Bar Association. Find out more about how ADR can help resolve your dispute by calling 516-747-4070 or visit nassaubar.org.
Once again, we continue with Law You Should Know. From the Mineola Law Firm of Shane, Dox, Denise, Corker, and Sauer, here is attorney Kenneth J. Landau.
Hi, this is Ken Landau, and welcome back to Law You Should Know. We're talking about wage and hour litigation, and our guest is attorney Christopher Marlborough. He has offices in Melville, and he limits his practice to this area of the law. Chris, you were telling us about what gives rise to many wage theft claims. I know another area of litigation is tips. Those tip cups we may see at a donut shop or at a restaurant. What right does an employer have to a share of those, and can they litigate if they're not getting their fair share?
Well, let me tell you might have read in the news that this is a hot topic because the Trump administration is considering making changes to the tip rules and the tip sharing rules. However, that is irrelevant to us in New York, where there's a higher minimum wage, there's a higher tip credit wage, and there is also a statute that says that tips belong to the worker. So under New York state law, those tips are the workers, and they cannot be disenfranchised from those tips. Management cannot stick their hand in the tip jar. And service staff are the ones who are entitled to the tips. What this latest proposal is supposed to include is that back of the house workers, people who are not the direct service staff, would be able to share in those tips. But the idea is, well, then ultimately